Hello, my name is Eleanor Winslet and I'm a Senior Associate in Reed Smith's Employment Group. I'm going to tell you all you need to know about the new Shared Parental Leave regulations in 6 minutes or less. The Shared Parental Leave regulations are now in force. Parents of children who are due to be born or adopted on or after the 5th of April 2015 will be entitled to 50 weeks of shared leave and have the opportunity to request leave either simultaneously or consecutively in continuous or discontinuous blocks. Parents remain entitled to 52 weeks of maternity or adoption and 2 weeks of paternity leave. However, if the mother or primary adopter opts to curtail their maternity or adoption leave period, the remaining leave can be divided between the parents. It remains compulsory for a mother to take 2 weeks of maternity leave following the birth of her child, and her maternity leave can only be shared after that time, so in theory, up to 50 weeks of the maternity leave may be shared. Once maternity or adoption leave has been curtailed, parents have the right to request whichever pattern of leave they wish, although this is subject to the employers of both agreeing to that pattern. The previous system of additional paternity leave, or APL, will remain in force for parents of babies due to be born or adopted prior to the 5th of April. Those entitled to the new SPL rights will have access to a far more flexible system which can be tailored to each family's requirements as long as these fit with the parents' employers. For SPL, in contrast to APL, parents can take leave at the same time and in a number of blocks. Fathers or partners are also able to take a far longer period of leave under SPL, namely up to a maximum of 50 weeks, compared to up to 26 weeks from the 20th week after the baby was born or adopted under APL. To qualify for the right, employees must provide the following notices to their respective employers: notice to curtail maternity leave, notice of entitlement and intention to take shared parental leave, and a period of leave notice. There are complex provisions in place relating to when the curtailment notice may be revoked. There is also the potential for 3 separate period of leave notices to be issued. Where the eligibility requirements are satisfied and notices are provided within the relevant timescales, an employer must agree to any request by an employee to take continuous leave in one block. Importantly, the period of leave notice must be provided at least 8 weeks before the first day of the SPL. Where the employee requests to take leave in a number of discontinuous blocks, the employer is able to refuse this request without giving reasons. Employees who are eligible will be entitled to up to 37 weeks of statutory shared parental pay, which may be shared between the parents. It will be interesting to see whether employers choose to make enhanced pay available to those on shared parental leave, if they currently enhance maternity pay. There is evidence to suggest that many employers will opt to do so. Employers will want to think about whether there is a need to be competitive, but also the potential for indirect sex discrimination claims. The point was raised unsuccessfully in the case of Shooter and Ford Motor Company in relation to the additional paternity pay provisions, but this failed in large part due to the particular factors of the workforce in question. The SPL regulations provide a right not to be unfairly dismissed or subject to a detriment as a result of taking or intending to take SPL. There is also the right to return to the same role if no more than 26 weeks of leave is taken, or a suitable and appropriate role where a longer period of consecutive leave is taken, and it is not reasonably practicable for the employer to return to their former role. During SPL, parents are entitled to 20 additional keeping in touch days, known as split days, without bringing the SPL period to an end. This is 20 days to be shared between the parents rather than 20 days each. The notification requirements for SPL are complicated, and so it would be beneficial for employers to put in place a clear shared parental leave policy, including the relevant forms for employees to complete. Providing training to managers would also be useful given the challenges of the new rules. Finally, it is also recommended that employers give thought to whether to enhance pay for employees taking shared parental leave. I hope that this podcast has been useful to you. If you have any questions, please contact me or your usual Reed Smith contact by following the links on the platform on which you reach this podcast.